All right. Good evening, everyone. This is Mayor's public hearing. Today is at 5 p.m. on the 22nd of October, and so we're going to call this Mayor's public hearing to order at 5 o'clock. This is the Mayor's public hearing for local law number 6 of 2025 of the Common Council of the City of Kingston, New York, establishing a charter review commission. And so at this point, is there anyone here to speak either for or against or about the Charter Review Commission? All right, go ahead. You should be able, once it's turned on, you should be good.
Yep, it did. My name is William J. Piersa, and I currently serve as an assistant corporation counsel. I'm here to share information relevant to the Charter Reform Commission process underlying this proposed local law. Charter reform is a valuable government modernization initiative. Kingston, as a city, has certainly undergone changes as this country has. It is critical that the foundational documents that serve as the backbone of our democracy should adapt as well. Our charter exists within a hierarchy of laws and reflects state delegated authority. It, like all other local authority, is subject to state and federal preemption principles that are both complicated and frequently litigated. Within this system, the City of Kingston may act through any number of means, those being policies, like the property disposition policy, resolutions, which carry the least weight, ordinances, like the form-based code, local laws, and of course, a municipal charter. In the hierarchy of legislative materials, the Charter, our constitutional equivalent, is a foundational document that cannot be changed in a simple manner, and that, unlike resolutions that are easy to repeal, must be drafted to survive outcomes almost entirely impossible to predict. The City of Rochester charter case, one in which this city appeared as an amici, makes this clear. Ultimately, a majority of judges on the state's highest court concluded that one revised phrase in Rochester's charter amendments constituted a surrender of the city council's authority, power that would have allowed the city to create a civilian complaint review board that an overwhelming majority of its voters had already approved. No committee reports, testimony, or other evidence in that case proved that Rochester City Council intended to surrender its power, and the consequences of their revisions only became apparent after case law developments. Still, the city of Rochester had lost its capacity to craft a local remedy to a serious civil rights problem. Administrative code changes do not typically have this same catastrophic and unforeseeable impact. On a separate but related note, it is important to make all of the city's legislative materials readily accessible. This becomes even more critical for anyone engaged in the charter reform process. The bulk of our city's legislative materials remain in paper-only form. None are available in a text searchable format. Not only that, a climate-controlled vault in the Office of Corporation Counsel stores almost a century of municipal records that will be inaccessible to members of the Charter Reform Commission. These records contain the city's history, hours of intense thought and scrutiny by past councils, and many still in effect resolutions that may not have been digitized or available in any other form. A Charter Reform Commission tasked with recommending revisions should have full access to prior versions of the city's charter and all other legislative materials to better understand our local system of government and make informed decisions about what should be changed. Thank you.
All right. Thank you very much for your comment. Are there any other comments related to local law number 6 of 2025? Hearing none, we are going to close this mayor's public hearing at 5:04 p.m. All right. Thank you all very much for coming.